Um, I'm Professor Strong, and I've never actually spoken to the full panoply of Room 7 before. Everybody else has always been hiding down in the front, so I haven't had to be so loud. It is my great pleasure and honor today to be introducing our keynote speaker, Gary Bourne, all the way from London. You will tell by his accent that he is US born, or if not US born, he may have been born in Europe. May have been born in Europe. Anyway, but he's one of us. Although he lives over there. Gary has a fantastic resume, and I hope that most of you have looked on the website to see his background a bit. I will not go into it in great detail, but the one thing I like to say is Gary's a prolific author. So I'll give you his background in a moment, but I'll also let you sit in some silence. This is one of his books. Here's another one that he did. Did this one a few years previous to that. This one just came out, he did with Bo Rutledge, who is going to be speaking later today, and this is just a little tidbit that he did on the side. So suffice it to say that Gary Bourne likes to write, and he's very good. He is, in fact, the world's leading expert on international commercial arbitration and international litigation. He was a Supreme Court clerk, although I was talking to someone yesterday or a day or two before, and that person was more impressed by the fact that he had clerked for Justice Friendly on the Second Circuit, which apparently Justice Friendly is even more kind of discerning than the Supreme Court. So Gary has them both. Gary has worked in Washington, D.C., in Berlin, and in London. He's currently based with Wilmer Hale in London, where he heads the 70-member International Arbitration Group. He sits as an arbitrator, he teaches, he writes, and I will move those in a second so you can see his face. He writes, and he also sits as an arbitrator. He has been active in over 550 arbitrations around the world, including 4 of the largest ICC arbitrations ever, which is quite a feat since they can get really big and very large figures. He was voted Advocate of the Year in the Global Arbitration Review's inaugural competition for that. He was voted the world's best international litigator by the Legal Media Group. Something that's not on his bio is he gets extremely embarrassed when you say nice things about him, so he is dying right now. But he is also a wonderful person. He teaches around the world. We are very honored to have him here. He teaches when he's not here. You may have heard of them: Harvard, Stanford, Virginia, few other ones. If you're internationally oriented, St. Gallen in Switzerland. So he prefers, I think, to teach students as opposed to talk to practitioners, because he very seldom speaks out in the kind of the professional circuit. I talk to when I teach lawyering, I'm not teaching it this year, but when I have the first year students in particular, I like to tell them that anything is possible when you go into law. You don't have to have come from a law family. Gary is the first lawyer in his family. He just told me this morning he had never even met a lawyer before he went to law school. So if you're the first lawyer in your family, you too can be Gary Bourne in a few years' time. We also talk in lawyering about the importance of negotiation. A lot of people come in, I'm going to litigate, and I'm just going to be litigating all day long. Gary started as a transactional lawyer, so has those negotiation skills. And I'm sure he still uses them to this day when he's talking with settlements and such. A few of the things that you may not be able to get off his bio: he was a college basketball player, a shooting guard back in the days before there was a three-point. So I don't think he's going to be playing basketball with any of you today, but you can kind of say, oh my goodness, all of this intelligence and sporting acumen as well. I will take this down, and so that the roar of applause can be heard fully by Mr. Bourne, please help me giving a big Missouri welcome to Gary Bourne.
Thank you very much, and if you can all hear me, that's a good sign. If you can't, though, please let me know, and I'll try and speak out. First, I really should have just let both Stacy continue her introduction. It was much more interesting and better than I'm sure anything I can do. I also probably should have let Frederic, Christopher, and Louise continue their panel discussion this morning. I'm not sure whether all of you had an opportunity to listen to the panel discussion, but it was exceptional in terms of the quality and scope, and I really do hope that I'm able to provide something that is at least partially as interesting. It's a unique commentary, I think, for the University of Missouri, for Dean Dessem, Professor Bailey, and most of all for Stacy Strong, for putting together a conference of this quality and this scope. Most law schools, frankly all law schools, I think, would give their eye teeth to be able to put together a symposium that draws people from around the world to make presentations of this quality, and my own, no doubt, excluded from that commentary. But I personally am very grateful and appreciative for the invitation to be able to address all of you in the company of such distinguished colleagues. Thank you very much. So I thought about what I should talk about and looked at the title for this symposium, Border Skirmishes, and in particular, border skirmishes in international commercial arbitration. And in putting together my remarks, didn't really get much past that title. I asked myself, what are they? What are border skirmishes? And I asked myself, why are they? Why are there border skirmishes? Why do they exist? And then I asked myself, well, are they a bad thing? Are border skirmishes bad, or on the contrary, are they constructive? And finally, I asked myself, putting aside just how good or bad or indifferent they are, is there any way the international commercial arbitration system could be made a little bit better? Could it be improved, given the first three questions that I put to myself? And having asked those three questions and the final fourth question, I decided that could pretty much be the subject of this talk. And I think it's a credit to Professor Strong for having put together a provocative title and program that hopefully lets me use it as a springboard for my remarks. And in the course of my remarks, I hope to address each of those four questions. I'd like to start, before I go too deeply into any of them, with a little bit of background, setting the context, if you will, from a bird's eye perspective of where international commercial arbitration lies, where, using the border analogy or metaphor, it is situated in the general landscape of international dispute resolution. And I'd like to begin with something other than international commercial arbitration, but nonetheless something which conjures up borders or boundaries, and that is state-to-state arbitration, one form of international arbitration similar to, but as we'll see, a little different from international commercial arbitration. And I think by looking at state-to-state arbitration just briefly, we can inform ourselves better about how to go about answering the four questions that I raised. State-to-state arbitration, of course, is arbitration between two sovereign states or things like two sovereign states. Examples would include the famous Alabama arbitration between the United Kingdom and the United States in the 1870s, where the United States and the United Kingdom agreed to submit a dispute over alleged violations of the laws of neutrality to a state-to-state arbitral tribunal constituted and sitting in Geneva, Switzerland, and applying then customary rules of international law. Another example of a state-to-state arbitration would be the so-called Abyei arbitration between Sudan, the Republic of Sudan, and the southern bits of Sudan then not quite an independent state, now, of course, an independent state. And in these state-to-state arbitrations, which in fact are some of the earliest examples historically of arbitration at all, one sees very little, if any, involvement of national courts. Indeed, one sees virtually no involvement of national courts. One sees an international legal system in which an international arbitral tribunal applies rules of international law without any real reference to national law. National courts play no role in that international arbitral process. And there are, and this is a theme that I'll come back to in my remarks, no real borders between the international legal system and the national legal system, national courts and national law. The two exist largely autonomously and independently. And as we'll see, not surprisingly, since there are no borders, there are no real border skirmishes. I'd like to touch just briefly, having outlined state-to-state arbitration, on investment arbitration, which bears a number of similarities to state-to-state arbitration. Investment arbitrations arise in a specialized area between foreign investors and host states. Foreign investors typically are permitted to bring, assuming you've got consent from the relevant state, so-called investor state or investment treaty claims against the state for various violations of international law norms. The ICSID Convention governs many but not all of those disputes, and like state-to-state arbitration, provides a largely autonomous international legal regime that makes little reference to national courts or national law. Indeed, Article 26 of the ICSID Convention excludes national courts from any meaningful role in the investor-state arbitral process. The ICSID regime provides an internal mechanism for selecting arbitrators, for dealing with matters like provisional measures, and for running the arbitral process. Again, it is a mechanism, an international arbitration mechanism, which has few borders with national law. It's one that operates autonomously and independently as an international legal regime. The one exception, in contrast to state arbitration, is that ICSID arbitral awards are enforceable in national courts, where there is a border, if you will, between the international legal order and national courts. But it is just one border, or border crossing, and it's one where, although I don't have time to go into it today, national courts have a very limited role indeed. In contrast to those two largely autonomous and independent international legal regimes, we have international commercial arbitration. As we know, as we've heard from Frederic and Chris's introduction, international commercial arbitration can cover a host of matters. Louise introduced us to the concept that it can cover things even beyond traditional commercial matters and extend to matters of sports arbitration, sports disputes. In general, any international commercial dispute that the parties consent to have arbitrated can be submitted to international commercial arbitrations and resolved in that manner. Unlike state-to-state and investor-state arbitrations, though, international commercial arbitration involves a hybrid legal regime that entails extensive interaction between, on the one hand, an international legal order, and on the other hand, national courts and national law. That hybrid legal regime arises from the New York Convention, the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, and from national legislation, arbitration legislation, which Frederic mentioned to you, primarily the UNCITRAL model law, in this country, the Federal Arbitration Act, which implements the New York Convention. And those two sets of instruments, the New York Convention, other international instruments like it, such as the European Convention, the Inter-American Convention, implemented by national arbitration statutes, both, as we will see, give extremely important roles to national courts in enforcing and supporting the international commercial arbitral process. As a consequence of those important roles, there are lots of what we can refer to as either borders or border crossings between the international legal order and the national legal order. And not surprisingly, as we will see, there are also lots of border skirmishes between those two regimes, which you don't see reflected in the other international arbitration contexts that I've referred to. What I'd like to do now is talk a little bit more about the international commercial arbitration regime. Look at it instead of from a 50,000-foot perspective in the context of the other forms of international arbitration that I've discussed. Look at it just itself. Examine it more closely. And what we see there is a tension between internationalism on the one hand and national law and courts on the other. And what we can see is this tension in each of the three main segments of the international arbitral process: international arbitration agreements, international arbitral procedures, and international arbitral awards. Starting first with international arbitral procedures, which are, in a sense, the heart of the arbitral process, one can see how international commercial arbitration has aspirations to be, in many ways, purely international. One of the defining characteristics of international commercial arbitration has been the effort to create a neutral, objective, and expert procedure detached from national rules of civil procedure, detached from national laws, which is subject primarily to the parties' autonomy and to the tribunal's procedural discretion. One can see, for example, from Article 20 of the UNCITRAL model law, which provides for the arbitral procedures to be governed by the parties' autonomous choices and, absent such choices, by the tribunal's procedural discretion, an effort to detach international arbitration procedures from any particular national law, including the national law of the arbitral seat. And indeed, some of the most enthusiastic proponents of international commercial arbitration argue for truly or completely internationalized procedures which detach arbitration, international commercial arbitration, entirely from national laws and national procedures, both those of the arbitral seat and those of other countries. That procedural aspiration towards internationalism is reflected as well in what can be called the principle of judicial non-interference in arbitral procedures. That principle, adopted both in this country and many other countries, provides that courts, national courts, will not interfere on an interlocutory basis in the ongoing procedures of an international arbitration. That principle is reflected in Article 5 of the UNCITRAL model law, which provides that save as provided in the law itself. Courts will not intervene in the arbitral process, and that provision has been interpreted expansively by national courts to abstain from interlocutory rulings, for example, on questions of jurisdiction or choice of law or disclosure or other interlocutory manners during the arbitral process, all of which reinforces the conception of a purely international arbitral process detached from both the substantive norms and from the active intervention of national courts in the arbitral process. That same aspiration towards internationalism is reflected as well in the approach towards international arbitration agreements. Again, both under the UNCITRAL model law, the FAA, and other national laws. All of those legal systems have, for the last 80 years, adopted the principle of so-called separability or severability, the autonomy of the international arbitration agreement. That autonomy detaches the international arbitration agreement from the party's underlying contract, from the choice of law rules that govern the party's underlying contract, instead looking to a specialized set of choice of law rules that apply by virtue of the New York Convention and national law, Article 51A in particular, but also national law rules. And finally, and perhaps most enthusiastically, some legal systems, France and the United States, ironically taking both the same position towards something, viewing international arbitration agreements as detached from national law. In France, in cases such as Dalico, French Supreme Court and other French courts providing specifically that international arbitration agreements are governed by national law, detached by international law, detached from national legal systems. In the United States, in cases like Rhone and Lade, the U.S. courts holding that international arbitration agreements are subject to the New York Convention, the international principles of which override national laws in a wide range of circumstances. Again, the aspiration of the international commercial arbitration process being to escape from the particularities of national law. Just as there was an effort in arbitral procedures to escape from the particular procedural rules, civil procedure regimes of individual states, so with regard to international arbitration agreements, an effort to escape from the particularities of national law, which would govern, and in many cases perhaps disfavor, the validity of international arbitration agreements. And finally, international arbitral awards. There again, the aspirations of the international commercial arbitration regime are to internationalize those awards, to subject them by virtue of Articles 3, 4, and 5 of the New York Convention and implementing legislation in various states, Article 35 of the UNCITRAL model law, provisions of the second chapter of the FAA, to an international regime which upholds the enforceability of those awards, save in the most limited circumstances. Again, the effort is to detach international arbitral awards from the particularities and potential hostilities of national law. Taken together, these three pieces present a package which sometimes is described in particular by its more enthusiastic proponents as a purely international regime. This regime reaches its height, for example, where awards annulled in a particular jurisdiction in the arbitral seat are nonetheless regarded as enforceable in other states mandatorily under the New York Convention. These awards, sometimes referred to as a-national awards, giving a specific recognition in its title to the international aspirations of the international commercial arbitration system, seeks to denationalize the arbitral process, subject it to an international legal regime which displaces otherwise applicable national law. That is the international aspiration of the international commercial arbitration regime. At the same time, despite all that, national courts, when we keep our feet on the ground, continue to play an exceptionally important role in the international commercial arbitration process. And the burden of my discussion today will be on underscoring the importance of national courts and national law in the international commercial arbitration process. It's to suggest that we need to give equal weight to the national aspects of this hybrid regime in addition to the international aspects, to keep those national aspects in mind. In particular, when we look at the New York Convention, it envisages a unique enforcement mechanism for both international arbitration agreements and international arbitral awards. We can begin with international arbitration agreements. Article 2 of the New York Convention provides for national courts in the contracting states, the 145 states that are party to the New York Convention, to refer disputes to arbitration when they're subject to an international arbitration agreement. In so doing, the New York Convention mandatorily requires national courts to refer disputes to arbitration. And indeed, although I don't have time to go into it as much as I would like, it does so in significant part by reference to national law standards. At the same time, the New York Convention, through Article 5, Articles 3 and 5 of the Convention, enlists national courts, mandatorily requiring them to recognize and enforce foreign arbitral awards. In so doing, by requiring national courts to enforce arbitral agreements and to enforce arbitral awards, the Convention necessarily requires national courts, necessarily involves national courts and national law in the international arbitral process. And finally, just briefly, but also importantly, the New York Convention, the UNCITRAL model law, and national arbitration legislation in all other developed states contemplates that national courts will play a highly significant role in supporting and assisting the international arbitral process. That includes matters such as appointment of arbitrators if the parties haven't so provided. It includes resolution of jurisdictional disputes. It includes provisional measures in aid of arbitration, and it includes evidence taking in aid of international arbitration. Despite the aspirations of the international commercial arbitration process to be truly international, the New York Convention recognizes and indeed confirms and entrenches the vital importance of national law and national courts in making this hybrid system work. Most importantly, in enforcing international arbitration agreements, making those agreements actually work, enforcing international arbitral awards, making it so that the results of the arbitral process actually have effect, and finally, supporting the arbitral process. With that background, let's ask ourselves then, what are these border skirmishes that this symposium, this conference considers? These border disputes, I think, can be described as disputes over the allocation of competence between national courts on the one hand and international tribunals on the other, and disputes over the applicable legal standards, in particular international or national, in international commercial arbitration. Allocations of competence and substantive legal rules. And in each case, the border skirmishes that are most interesting and that this symposium considers involve those allocations of competence or differences between applicable legal standards. And I'll just run through these quickly by way of giving you an overview of the geography, to continue our boundary metaphor, our border metaphor, of the problem. One set of border skirmishes involves the standards for the validity of international arbitration agreements. There, one can see a tension between national law and international law on such issues as A, non-arbitrability. The New York Convention, Articles 2.1 and 2.3, require contracting states to enforce international arbitration agreements. On the other hand, the Convention provides and contemplates that states will be able to declare certain categories of disputes non-arbitrable under national law and refuse to compel arbitration. Border skirmishes occur where there are debates about whether a dispute is non-arbitrable or not. Similar rationale applies with regard to the formal requirements for arbitration agreements. Article 2.2 of the New York Convention, more broadly Article 2 itself, imposes certain form requirements. Are those a uniformly applicable, mandatory, formal rule for arbitration agreements? Or are they ones which states can either exceed or not exceed, provide less demanding form requirements? Again, national courts and international tribunals differ about those issues. Again, there have been border skirmishes with regard to the choice of law applicable to the validity of international arbitration agreements under Article 5.1a of the Convention. Are there national choice of law rules that should apply? Should purely international principles apply under Article 2 of the Convention? Or does national law have a role? The same sorts of border skirmishes arise with regard to international arbitral awards. For example, although Articles 3 and 5 of the New York Convention require contracting states to recognize and enforce arbitral awards, they also acknowledge exceptions to that obligation, including in Article 5.2, exceptions based on national law, in particular for non-arbitrability, which I've already alluded to, and for public policy, national public policy. And to what extent does the New York Convention and the international regime it establishes override or alter those national public policy rules? Again, another set of border skirmishes arises with regard to the allocation of competence between national courts and arbitral tribunals in considering jurisdictional objections to international arbitration agreements. To what extent should a national court, for example, under Article 8 of the UNCITRAL model law, consider a jurisdictional dispute de novo? Should it consider the dispute on the merits and decide whether or not there is a valid arbitration agreement, as opposed, for example, to referring the dispute based on a minimal prima facie inquiry into the existence of an arbitration agreement to the arbitral tribunal to make that decision? To what extent should competence be allocated to the national court in the first instance to decide whether there's an arbitration agreement, as opposed to the arbitral tribunal to decide in the first instance whether there is an arbitration agreement? Here, you see divergent national approaches in the United States. There's a tendency for courts to do a full interlocutory review to consider whether or not there is a valid arbitration agreement before referring parties to arbitration. In France, in some UNCITRAL model law jurisdictions, one sees a very different approach. The court simply asks whether prima facie there's a reasonable argument that there's an international arbitration agreement. If so, the dispute is then referred to arbitration for the arbitral tribunal to make the initial jurisdictional decision. There are additional questions of the allocation of competence between national courts and international arbitral tribunals. For example, may national courts issue anti-arbitration injunctions? If the national court concludes that there's no valid arbitration agreement, can it enjoin, order the suspension or dismissal of an international arbitration that has been brought pursuant to the putative arbitration agreement? And conversely, to what extent can an international arbitral tribunal issue an anti-suit injunction, ordering parties not to proceed in national courts in violation of an arbitration agreement? And finally, there's a set of border skirmishes that concerns international arbitral awards and the allocation of competence between arbitral tribunals and national courts. There are, in particular, disputes over the proper annulment or vacatur forum for an international arbitral award. Is it only in the arbitral seat, the place of the arbitration, or, as some courts, Indian, Pakistani, Indonesian, have held, can other courts outside the arbitral seat annul an award? There's also the question that I referred to previously of whether an annulled award can be recognized elsewhere or must be recognized elsewhere under Article 5 of the New York Convention. It is a quintessential example of the arbitral process being completely internationalized, where an award annulled in the arbitral seat by a national court nonetheless arguably must be mandatorily enforced elsewhere in other national courts. With that, an admittedly whirlwind tour of the possible categories of border skirmishes in the context of international commercial arbitration. I'd like to turn to an effort to answer the first of the questions that I alluded to. What are border skirmishes? We've just walked through a number of examples of border skirmishes in the international commercial arbitration context. Let's turn to the second question. Why are there border disputes? What causes these border skirmishes? And I think the answer emerges reasonably clearly from what I've already described. There are border skirmishes because there are numerous borders and border crossings between the international legal regime of international commercial arbitration and the national legal regime that supports that international process. It's instructive in this regard to look to the alternative model that I described at the outset of my talk of state-to-state arbitration, where you have a purely international process that does not look to national courts to enforce it. It's not surprising that in state-to-state arbitrations, which don't rely on national courts, that you would not have this fairly significant number of border skirmishes. There's no need for the international process. Perhaps there's a need, but there's no occasion for the international arbitral process to use national courts to enforce it. National courts play no role in enforcing state-to-state arbitration agreements or state-to-state arbitration awards. And there are no border skirmishes between those two regimes because there are no borders. There's no support, no assistance from one regime to the other. And in contrast, in international commercial arbitration, in this hybrid regime where national courts play an essential role in giving effect to and supporting the international process, national courts naturally, inevitably skirmish with those whose agreements and awards they are called upon to enforce. That is the explanation for why there are border skirmishes, which leads us naturally to the next question of, are these skirmishes, is this laundry list of disputes about how the two systems interact with one another a bad thing, an indifferent thing, or a good thing? And I would like to suggest that it's in fact a good thing, a healthy thing, and a phenomenon that involves sort of creative and constructive tension and mutual benefit. And I'd like to start by underscoring how unique and how uniquely effective the hybrid regime for international commercial arbitration is, and in particular to contrast it with the efficacy of the regime for state-to-state arbitration. It is vitally important to understand how well the New York Convention works, what a uniquely effective mechanism it, the model law, and similar national arbitration legislation is, how uniquely effective they are in giving effect to the international commercial arbitration process. The vast majority of international commercial arbitration agreements are effectively enforced. They're so effectively enforced that they often don't produce disputes. When they do produce disputes, they're effectively enforced both by international arbitral tribunals and by national courts. The same conclusion applies for the most part to international arbitral awards. The vast majority of international arbitral awards are voluntarily complied with. If they're not voluntarily complied with, they're effectively enforced in national courts through the mechanism of the New York Convention. There is an important category of cases where arbitral awards are annulled or denied recognition, but that shouldn't cause alarm or surprise. The function of national courts under the New York Convention, the Central Model Law, and other equivalent instruments is precisely to provide a control mechanism, both through annulment and non-recognition, to prevent awards from being enforced in certain exceptional cases where basic standards of procedural fairness or an absence of consent are involved. It's not an emblem of dysfunction that the arbitral process sometimes does not enforce arbitral awards. Rather, it's an instance of the arbitral process properly working by denying recognition and enforcement to awards that shouldn't be recognized and enforced. It's also important to think about this process for enforcing international arbitration agreements and international arbitral awards with their aspirations for international status. There is no centralized enforcement authority for international arbitration agreements or awards. Instead, there is a highly decentralized enforcement authority in which national courts are enlisted and mandatorily required to give effect to international arbitration agreements and international arbitral awards, effectively making the courts of 145 countries the agents of the international process. Not surprisingly, as part of that bargain, national courts want some piece of the action. They want some role in ensuring that the underlying process had integrity, was something the parties had genuinely consented to. This process should be contrasted with the process for state-to-state arbitration, the purely international regime which I described and which some proponents of international commercial arbitrations aspire towards. Importantly, that regime has no centralized enforcement authority on the one hand, and also has no 145 sets of national courts to enforce it on the other hand. And as a consequence, it shouldn't be surprising that a substantial number of state-to-state arbitration agreements, A, don't get respected, or B, produce awards that don't get respected. There are mechanisms, informal mechanisms, through reciprocity, reputational disadvantages and the like, that incline states to give effect to state arbitral awards or to decisions by international tribunals. But those enforcement mechanisms are markedly less effective than the hybrid blend between international tribunals and national courts that exists with regard to international commercial arbitration. Turning then, with that background, more specifically to my question, our question as to whether or not border skirmishes are a good thing or a bad thing or an indifferent thing, I would suggest that they actually are a good thing in most instances. As I've already intimated, in many instances, for example, annulment in the arbitral seat of an arbitral award, denial of recognition of an arbitral award, or refusal to enforce an international arbitration agreement, instances of skirmishes between the two legal systems, it's entirely appropriate for the national courts to do what they do. If there's no arbitration agreement, if the parties haven't consented to arbitrate, national courts shouldn't recognize and enforce the arbitration agreement. Equally, if the arbitration award is based upon patently unfair arbitral procedures, this does happen. Arbitrators are human. They make mistakes like everyone else. National courts should either annul the award or deny recognition. National courts doing that is not an example of a dysfunctional border skirmish. Rather, it's an example of the system working the way that it should in a cooperative manner in which international tribunals and national courts share the work, share the burden. It's an inevitable aspect of the control function that national courts play in the arbitral process. It may be a limited control function. Indeed, it is a limited control function, but it's nonetheless a healthy, intended part of the system. There are some other aspects or examples of border skirmishes which are a little bit different. These refer, I have in mind some of the disputes concerning the allocation of competence between national courts and international tribunals, where I think one can fairly say the boundary, the border between the international regime and the national regime is being worked out in a healthy process, a constructive process of dialogue. A good example I would suggest is the question of the allocation of competence to decide jurisdictional disputes on an interlocutory basis. As I mentioned, there the United States adopts an approach of full review on an interlocutory basis. Presented with an alleged international arbitration agreement, a U.S. court will decide de novo and finally whether or not there is such an agreement. In contrast, other courts, I mentioned French courts, some model law jurisdictions, will only look at the question on a prima facie basis and refer the dispute in the first instance to the arbitrators to decide, subject to subsequent judicial review. One can fairly have differences of opinion about which of these two approaches is better. Importantly, though, the process of considering and debating those two alternative approaches is a healthy one that can hopefully over time determine which of the two approaches is better, or as I have suggested in some of my writings, whether a more nuanced hybrid approach between the two is superior. Finally, there are, in the category of border skirmishes, because nothing is ever perfect, a few pathological examples. For example, when a court outside the arbitral seat purports to annul an award, as I've mentioned, Indian and Pakistani courts have sometimes done, that is an example of what I would call a border incursion. It's an example of a national court clearly overstepping the boundaries, the borders contemplated by both the New York Convention and most national laws. That sort of border incursion is pathological and is something that the international system does and should prohibit. And finally, and I only have 2 minutes left to address this final question, how could this system, which I've tried to suggest works reasonably well, how could it be improved? How could a system that has these border skirmishes, which for the most part I believe are either contemplated or a healthy process of dialogue, be made better? And I have, by way of proposals or suggestions, only 3 short comments, which I'll briefly allude to. First, beware of international fantasies. Always recognize that the international commercial arbitration system contemplates a hybrid, contemplates a cooperative relationship in which national courts and international arbitral tribunals function together. Efforts to over-internationalize the process are no less troubling than efforts to over-nationalize the process. Second big picture point, good fences make good neighbors. What do I mean by that? Good fences make good neighbors in the sense that arbitral legislation, international arbitration statutes that clearly prescribe the respective relationships between national courts and international tribunals are a good thing. In that regard, I would suggest the UNCITRAL model law and national laws developing on it are a better approach, by and large, than a purely common law approach, as in this country under the FAA, which leaves so much up to grabs in common law development of the relationship between national courts and international arbitral tribunals. In particular, I think the model law provides greater predictability and consistency, especially given that when you have the fact that you will inevitably have trial courts with limited experience with international arbitration attempting to apply international instruments. At the same time, the model law limits the scope of discretion that is given over to national judiciaries, which in the scheme of things I think makes sense. And my final proposal, and moving on along perhaps a little too quickly, it's not just that good fences make good neighbors, but international fences make better neighbors. And by this I mean the greater the extent of internationalization of the borders, the better. and this may sound to some extent in tension with what I've described previously, but it's not. The basic concept is the New York Convention provides a constitutional regime that defines the relationship between national law and national courts on the one hand and international arbitral tribunals on the other. The New York Convention, whether or not it's considered to be self-executing, imposes binding international commitments on the contracting states and national courts in the contracting states. Those commitments contain within them definitions of the relationship between national courts and national law on the one hand, and international commitments and international tribunals on the other. And one of the real challenges for improving the international commercial arbitral process is articulating that constitutional regime and better defining with international standards the relationship between national law and international tribunals on the other hand. Thank you. George?
Gary, that's superb, and I thank you for it. At the very end of your remarks, you got to the question that I think is the next step in the inquiry. In effect, when you were saying our border skirmish is a good thing, or not, or indifferent, what you were really saying, I think, was our borders a good thing. Is it good to have a hybrid system? And if so, then the price we pay is the occasional skirmish. In other words, it seemed as though you weren't quite saying skirmishes are good, and you were saying borders were good, and skirmishes followed from borders. I could be mistaken about that. But what I'm coming to then is the question of whether, in addition to lauding the hybrid character, which I share with you, should we then also develop your third point, which is, should we, and how would we, how should I put this, enhance the likelihood that the police at the borders, such as they are using the same standards, that national laws resemble national assumptions, more resemble international precepts than they now do. And if you think in your last remark that it would be good for the borders to be international, the fences to be international, I think in effect you're answering my question, which is that skirmishes are not really all that great. Although I know some people argue that they are. Skirmishes are not that great. What's really great are the borders. And we should then also seek to reduce the number of skirmishes while maintaining the borders. And if that's your view, then what you're really saying is borders are good, skirmishes I'm not so sure about.
Not exactly. Those are very, very thoughtful comments, and I appreciate the opportunity to go beyond my allotted time in the form of an answer. I actually think border skirmishes, as distinguished from just borders, are good, in the same way that appeals, as distinguished from first instance decisions, are good. The control mechanism in the international commercial arbitration regime is through national courts in the annulment and recognition process. It is different from the appeal process in national courts in that the scope for control is greatly reduced, in part because commercial parties agreeing to arbitration want it to be greatly reduced. Importantly, though, I think the skirmishing in which a national court annuls an award or denies recognition to an award or refuses to enforce an agreement is not a bad thing, but a good thing. It can be abused. There can be too much of any good thing. But the fact that there is a measure of control and that some awards are annulled by the Swiss Federal Tribunal for Casts, Louise will tell us, and some awards denied recognition isn't, as I tried to suggest previously, dysfunctional, but precisely functional. Think about how many trial court decisions are reversed on appeal. It's a different standard in commercial arbitration, but arbitrators make mistakes just like trial courts do. And therefore, I think, insofar as annulment or non-recognition is an example of a skirmish, it is affirmatively good in at least an important set of cases. Also, in sort of responding, I think, to the second part of your question, if you didn't have that control function with national courts, what would you have? Would you really have a system in which national courts just plain enforced with no questions arbitral awards? Of course not. You don't have that in, for example, ICSID. In ICSID, you have annulment committees picked by the ICSID Secretariat, who I suspect most sophisticated practitioners would say is a worse mechanism than national courts recognizing arbitral awards. That's not to say that one might not be able to come up with an international review mechanism. It's been proposed by some commentators that would perform in a better way what national courts currently do. The political feasibility of that happening in any of our lifetimes is extraordinarily low, and I think nobody has outlined a mechanism, for example, for some sort of international court of appeals from arbitral awards that sort of is really terribly appealing. Coming back and hopefully leaving time for some more questions, I do think that border skirmishes are often a good thing. Some border skirmishes are bad things, the incursions that I referred to, and I won't try to flesh out this concept here, but abusive annulments. Annulments can go beyond what I think the proper limits of the New York Convention are. The most challenging aspect of internationalizing the borders between these two regimes, I think, is figuring out the constitutional role of the New York Convention. What sorts of obligations it puts on courts in contracting states. I think it does put important ones on them going beyond just what the express terms of the convention do, but that's a topic for another day. Yes, Professor Gower.
Today we had a very interesting discussion with one of the panelists on the many uncertainties regarding the federal law preventing state law in federal arbitration law in the United States. I heard you saying that to the extent that good fences make good neighbors, it would not be a bad idea to allocate in a predictable way and a specific way which is the area of national courts and which one is the area of the arbitration tribunals. Do you foresee it's a case in the future where efforts could be made to complement either the text as skim and laconic as the New York Convention or the Federal Arbitration Act with more specific rules on the allocation of function between national courts and arbitration tribunals?
Yes, but I do see and can give you some, I hope, interesting examples of exactly such greater delineation of the borders, perhaps demarcation of the borders in national arbitration legislation. The best example is in the UNCITRAL model law, adopted in 1985, revised in 2006, and now being re-revised on a national basis in countries such as Scotland, in Singapore, and elsewhere, with more detailed prescriptions regarding the role of national courts, and in particular, the definition, the delimitation of the authority of national courts vis-a-vis international arbitral tribunals. And consistent with my view that good fences make good neighbors, I think this is in general a positive development. I think it is extremely hard realistically to imagine that the New York Convention is going to be effectively amended. It has 145 contracting parties. The political complexities of that happening are enormous. But I think through the mechanism of the model law as adopted in individual countries, that greater delimitation is possible. I'd also like to sort of give a nod, though, in the opposite direction, which is there are some benefits to a common law approach, which allows litigants on the one hand and courts and commentators on the other to work out in an evolutionary basis the appropriate relationship between national courts and international tribunals in a way that may be more nuanced and thoughtful than national legislative changes. And I think it's important for the process looked at broadly to allow for that sort of case-by-case analysis of different considerations to happen before legislative enactments overtake it. I think the common law working out does have certain and important benefits that just pure legislation doesn't necessarily have.
Unfortunately, I did see some other hands go up. We are going to need to take a break, and I realize that all of you would love to ask questions. We're going to have a certificate ceremony. We will then go back to the courtroom. If you can grab Gary on the way while the service is there, it'd be great. He might be available afterwards as well for questions. So can you please help me in thanking Gary for his time. Here as an official member of the executive board of the Chartered Institute of Arbitrators. I'm no longer a professor. I am now somebody else. But I give it to Gary.
Who are you?
Who am I?
They really are making me work for my lunch.
Sing for your supper.
But it's a great pleasure, and this in fact isn't really work. I am now taking off my lecturer hat and putting on my Announce the Winners hat, and I'm announcing the winners for the student writing competition of the Chartered Institute of Arbitrators, the North American branch, which was conducted in conjunction with this symposium. And this was a symposium or a competition that was open to students, law students at all levels, JD, LLM, and otherwise, and took submissions from all over the world. The competition was judged anonymously, and the winner gets a substantial financial award. I won't embarrass them with what the financial award is, as well as potential publication in the Journal of Dispute Resolution here. And I have certificates here. I feel like the Academy Awards or something. Certificates, envelopes here for 3 papers, the top 3 papers, and I'd like to ask the winners, whom I'm about to announce, to come forward when I call your name. The 3rd prize goes to a paper dealing with investment arbitration, and it is entitled The Hidden Duality of Summary Disposition of Claims in Investment Arbitration. And it's Parvan Petrov Parvanovich of Columbia Law School.
Somebody would pronounce my name as if I'm Croatian and I'm actually Bulgarian. So it's part of that. Thank you so much.
Why don't we just all stand and all face the camera? Here, come on, here, you too. Very camera shy, I think. Oops. Oh, sorry. And we have 2 Columbia professors here, so now we know that the news is going to make it back to Columbia.
Thank you so much.
Congratulations.
Second prize goes to another investor state comment. You can tell that my remarks this morning focused on the wrong things. It's called this is a great title, A Bit Unfair, an illustration of the backlash against international arbitration in Latin America, Chevron Corp versus Republic of Ecuador. And the author is David Maw, who hopefully can come forward.
From the University of Missouri. not here. Maybe David is in class learning more about exciting investment arbitration. I'm not sure, but please, all of your friends, your friends with David, say, yay, David.
And finally, first place in the competition goes to the interference of the Court of the Sea with international arbitration. It's a subject of great interest. You heard from my remarks to arbitrators and advocates and courts everywhere. It was written by Julia Carbone, an LLM from Cambridge in the United Kingdom. She, unfortunately, like David, can't be here today. She has a much better excuse. Thank you all for participating. Congratulations again to David, to Julia, and to Barbara.